begin. So thanks again for joining us for the Natural Resources Industry Liquidity, Operational, and Compliance Challenges webinar that we are offering today. As I mentioned previously, my name is Jason Castor, and I'm going to just set the stage for today's webinar before I turn it over to our moderator that's going to guide us through the balance of today's presentation. The webinar format, as all of you have registered, all of your lines will be muted. We will be, however, accepting questions through our chat function today. So for any questions that you may have throughout the presentation today, please use the chat function, and we will do our best to address your questions throughout the session. Today's webinar will also be recorded, and the slides that we are going to be sharing with you today, along with the recorded version, will be sent to you after today's webinar. With that, I would now like to take the time, or I would like to turn the time over rather, to our moderator and the chair of the firm's Energy, Environmental, and Natural Resource Department, Mike Zodi. Mike, take it from here.
Thanks, Jason, and good morning, everyone. First of all, I just want to say I hope you and your families are all doing okay during this very challenging time as we're all adjusting to major changes in our lives. I hope you're all well. Today, we're focusing on financial and logistical issues in the energy, environment, and natural resources space. You can see our firm's webpage, the Parsons, Behle, and Latimer webpage, our coronavirus dedicated page for many presentations, materials on employment and other issues that have been emerging over the past couple of weeks. It's a great resource, so I encourage you to look there. I want to thank you for joining us again, for taking time out of your busy schedules. I know there are a lot of pressing issues for everyone out there. But we want to hear your questions. We wanted to set up this webinar to sort of cast a broad net over financial and logistical issues that we're seeing, some that are immediate, some that we see coming down the pike, start a good dialogue with our clients and our contacts, and continue the dialogue as we all work our way through this. So my goal and our goal as a department and as a firm on this webinar was really to bring collective experience together. We have some very senior attorneys who have lived through some very challenging times in the natural resources space, dips and downturns. None of us have seen anything or experienced anything like this. This is unprecedented, but there are some common themes with downturns. So again, we wanted to engage you, hear your questions, and start sharing some of the things we're seeing and anticipating. There will be a Q&A at the end, and also you can submit the questions through the chat function. I will be looking at those. I may submit some of those to the presenters as we're moving through the presentation. We do have a lot of material and a lot of presenters, so bear with us. We'll try and keep this on pace and keep you on time. With that said, I'll just give a quick overview of who's presenting. We have Rue Goodnow in our Reno office, who's presenting on liquidity issues and options before all of the relief packages started coming online. Then we're going to go to Ross Keogh up in our Missoula office. He's going to talk about the packages that have been rolling out that I'm sure you've heard a lot about, particularly the CARES Act. Craig Johnson will then delve into supply chain and receivables and logistical issues. Craig, having been in-house and living through very challenging times for some clients, has a lot of great insights. Bruce White then will pick up talking about reorganizations and bankruptcy issues, including with revisions to the code, the bankruptcy code, through the CARES Act. Again, Bruce, like the whole team, a lot of experience, a business lawyer who specializes in natural resources as well. Then Kevin Johnson is going to make his first appearance, and he'll appear again. He's going to do a quick overview of insurance reminders. And Jason, if we can move on to the next one, please. Thank you. Then Rue Goodnow will come back for a discussion on bonding issues, focusing on some of the pressures operators may be facing and thoughts on navigating those. Then we're going to come back to Kevin Johnson, who has been living the essential critical infrastructure issue in various jurisdictions, advising clients through that as the federal definitions are rolled out and implemented at the state and local level. And then Jacob Santini, who is in our environmental department, focuses on air issues, but does a lot of general compliance EPA work. He's going to talk about the EPA enforcement guidance and some other aspects of compliance relief and permitting challenges. And then again, I will wrap it up with a Q&A at the end. There's some contact information for all of us. And again, thank you for joining us. We feel for you in your industries, and we want to do what we can to help. With that, I will turn it over to Ruka now.
Thanks, Mike. When I entered the natural resources industry in the early 90s, Nevada was experiencing a prolonged period of mining recession. We had a lot of properties that were in care and maintenance or were going that direction. And so some of the experience that I'm going to talk about was derived through those challenging times that we experienced in the early 90s. Some of what we did was to represent mining companies through some of the large bankruptcies, the Pegasus bankruptcy, the Washington Group International bankruptcy. In both those cases, we represented the surety companies. And so some of my experience was derived from having wound up with properties that came out of the ownership or control of the operators and into the sphere of the bankruptcy court administration and surety funding. I think one of the questions that we've been fielding as a group has focused on workout and forbearance agreements, and I think those are medium-term solutions that probably will follow the liquidity issues that I want to talk about in just a moment. Lenders generally don't want to default. As it turns out, it's more beneficial for a lender to have a profitable performing client. Once a default happens, credits tend to go into the special assets group and take on an entirely new role for the lender, and their employees who administer those assets then change. We have experienced some of that already. Some assets being transferred over to SAG groups, but by and large, I think what the focus should be right now is on dealing with liquidity issues from the standpoint of simply starting first by reviewing, that's the first step, reviewing existing credit lines, determine what the terms are, then only after you've reviewed the existing credit lines should you talk with the financial institutions. That ought to be the second step. Maintain good, regular, positive communications with the bankers. It may be helpful, and I know a number of our clients and organizations that I sit on the board of have been in the process of drawing on lines that are open, have remaining undrawn balances. That the draw notice procedures, which are contained within the credit agreement, should be followed. And then finally, pay attention to the use of funds and restrictions on the use of funds requirements contained within the credit agreement, because those will be important as you proceed through the process of trying to increase your funding position for the future. Some of the concerns that you're going to have as operators, and we certainly have as counsel to operators, concern the loan covenants, the credit agreement covenants. Are they currently satisfied? And you should know those answers before you contact the bankers. It should be sort of a due diligence first step. One of the covenants that is important at a time like this is generally described as a material adverse effect covenant. They're generally drafted in a real broad fashion. Anything that in the lender's judgment might have a material adverse effect on a borrower could be a material adverse effect and might lead to changes in the availability of the line and the terms on which the line is available. Might give rise to a default even. Some credit agreements provide that a material adverse effect occurring not just before the line is initiated, but afterwards may be deemed a default. Also might give rise to a reduction in the available credit line. Some other common covenants that become important in times like these, both affirmative and negative covenants, leverage ratios, of course, cash flow requirements that statements be furnished quarterly, sometimes more often than that, and that they be evaluated. Insurance maintenance requirements, of course, are important. Payment of taxes, that the tax payments be made promptly, although, and this may be discussed a little bit later, some of the COVID-19 efforts by governments have reduced that burden substantially recently. Accounts payable performance and aging is another type of covenant to which the operator should be paying attention. Business cessation types of covenants require that businesses continue to operate and that there not be major changes or reductions in the business operations. Those might result in effects upon the availability of the credit, or might result in a default. There are also covenants which commonly restrict sales of both property and equipment. Pay particular attention to how your contemplated transactions to increase liquidity may affect your primary lines of credit because they, before you take that action, before you begin to go down that road, you should know whether or not the action may result in a default or a breach of the covenants, and be in consultation with the lenders to determine whether or not the action may be permitted. A lot of times we field questions about bankruptcy covenants. There are customarily covenants in existing loan agreements, credit agreements that talk about prohibitions on the filing of bankruptcy and other forms of debt relief, governmental and court intervention. Those are generally not enforceable. They're ipso facto clauses, is the language that's used in the bankruptcy code, and generally are not enforceable. Also, though, a related concept is the covenants that discuss litigation and the need to provide notice to the lender and under what conditions litigation, writs of execution, and encumbrances related to that may constitute a default. I want to turn just a minute to other ideas for possible liquidity solutions. We have seen a lot of or an increase in corporate bonding. Usually in this industry, that amounts to some sort of secured debenture or a secured convertible debenture with a feature that allows some conversion to equity, so that there's some upside negotiated by the venture capital or financing company or bank. Other ideas include streaming. We've done a number of streaming agreements in the fairly recent past. I expect maybe some of those will continue, especially in precious metals. Royalty deals are still being planned and still closing. And then there's the option of equity issuances, which is going to be, I think, pretty tough in this market. And then finally, another concept that might be utilized is equipment finance. This industry, as everybody knows, equipment is a very expensive part of the operation, very integral part of the operation, and there are a number of solutions that are commonly utilized to provide liquidity that relate to the financing of an operation's equipment. With that, I'm going to stop and Mike, turn things back to you, and I'll see if there are any questions at the end of the presentation.
Thanks, Rue.
Mike, just one thing really quickly.
Yes, Kevin.
Rue went through the financing documents. One of the things that's important is most of these financings are secured, so make sure you understand the security covenants, the limitations that you have on the sale of assets, encumbrances of assets based on your security agreements as well.
Thank you. Thank you, Rue. And just a reminder, if you have questions, use the chat function and shoot them my direction. Now I'm going to turn it over to Ross Keogh. I'm going to pose a question to Ross and maybe Rue as you roll into this next discussion of the relief packages. I'm curious, is there any requirement in the relief packages that are for loan-based options that you exhaust any existing lines of credit or other resources before you turn to the federal options?
Well, thank you, Mike. Yeah, I'll visit that question unless Rue wants to comment. So what I'm going to talk briefly about, and I do want to highlight, there's been two, and it does appear today that we'll probably have another, which will actually be the fourth kind of congressional response to COVID-19. The first one was the Response Act, which dealt with mandatory paid family medical leave and paid sick time. That bill actually, those requirements go into effect today. There are a lot more resources on those two elements on the firm's COVID-19 response page, and our employment group has been working diligently on those pieces. The CARES Act was the piece of legislation that passed on Friday, and I like to think of the CARES Act as sort of four legs to support the United States economy. And of those legs, there's about $2.2 trillion in spending that's divided between them. The first is we have direct taxpayer subsidies. These are the $1,200 payments. We're not going to talk about that at all today. The second leg is the $500 billion in Treasury-directed intervention funds. And I think Mike's question really gets to this program, which we're supposed to see some additional information about by the end of the week, as mandated by the Act. But what it basically looks like is the TARP program from 2008 with a whole bunch of additional strings and oversight. So Treasury is going to have the capacity for primarily larger type employers, those greater than 500, to make direct equity investments or to extend a loan or to provide a guarantee for existing debt. And that program, to Mike's point, does have a requirement that those that are seeking the funds really try to exhaust existing credit facilities before they can move forward. A lot of that money is earmarked or sort of capped for the airline industry, about $29 billion of the $500 billion, and another $17 billion is specifically capped or allocated for national security. but it's a significant option that's going to be available to a number of firms to try to support them during this time. I think there's a lot of flexibility, and we're going to see a lot of unique arrangements deployed by the Treasury in the use of that program. The last two legs of the table, which I'm going to talk primarily about in the presentation, is the $349 billion that's now available through the SBA 7A loan program, and then the tax credits and subsidies, which will be of interest. So onto what is called the PPP program. And what we've seen with a lot of our clients is they may not be directly interested, but it's their suppliers or distributors or other parts of the supply chain that can really benefit from this program. And so in that context, I think it's important to know sort of the fundamental framework and making sure that eligible businesses are looking at this as one of the options to stabilize their cash flows and maintain workforces through at least to the period June 30th. The program it provides a loan which is a function of monthly payroll costs. It's simply 2.5. The maximum loan amount is either 10 million or 2.5 of the average monthly payroll of the business. It's generally available to only those employers that have less than 500 employees. There's broad eligibility requirements that are significantly expanded from the traditional SBA 7A loan program. And you can use the loan proceeds the loan is a function of the payroll costs, and in calculating that, payroll includes salary, wages, commissions, and similar compensation, employee benefits, severance benefits, and state and local taxes. And I think very importantly, independent contractor expenses that are sort of routinely incurred. This is an area where we're expecting some guidance exactly how to count, but independent contractor expenses are going to be includable in determining what your average monthly payroll amount is to calculate the loan principal. Payroll costs are capped under the PPP program at $100,000. So you do have to make some adjustments for highly compensated employees. Once you have the loan, it can be spent in 4 areas: payroll costs, meaning the definition previously described, interest on existing debt facilities, rent, and also utilities. The loan doesn't require any personal guarantees. It's non-recourse. There's no requirement for collateral. There is no SBA fees and no prepayment fees associated with it. The loan, there's also forgiveness available with these loans, which I'll detail shortly. But if they aren't forgiven, there is a 10-year amortization with a maximum of 4% interest, and there's a general deferral of all obligations for the first 6 months. Once you have the slide deck, there's some links about SBA lenders that are available. The loan forgiveness piece is very significant and will, for most borrowers, effectively turn this into some sort of credit. It's available if you're able to maintain your full-time FTEs starting with the date that the loan is provided. And those amounts that are forgiven are not going to be subject to income tax, so long as you use the proceeds to pay for either payroll, interest on mortgage obligations, or covered rent. To calculate your forgiveness, you take the average number of FTEs from one of 2 periods, February 15th, 2019 to June 30th, 2019, or at the election January 1st, 2020 to February 15th, 2020. And then you look at the FTEs by pay period over the 8 weeks from the date you get the loan to determine how much proportional forgiveness is available. You can also limit your forgiveness if you reduce compensation from employees making less than $100,000 by more than 25%. So I'm going to turn now briefly to the other subsidies and programs in the CARES Act. Here's kind of a list of the slides we'll be talking about. First, if you have an existing SBA loan, there are broad deferral and interest forgiveness provisions provided in the CARES Act. There's $17 billion that has been allocated to these types of deferral programs. The CARES Act modifies the required minimum distributions. So if you have employees that are required to take RMDs, or you yourself have RMDs, you can sort of forget 2020 for being required to take them. And there's also a $100,000 loan that's now available for retirement. The CARES Act has two incentives that allow for alternative ways of compensating employees tax-free. The first, which this slide discusses, are tax-free payments on student loans. So employers can now pay portions of an employee's student loans, and that compensation isn't included in income to the employee. With the President's declaration of a national emergency on March 13th, 26 U.S. Code Section 139 was triggered. And this allows employers to pay employees, or really anyone, any reasonable expenses associated with adjusting to the COVID-19 pandemic. We see this as a way for employers to really support their employees, perhaps coupled with a salary reduction that still makes the employee fairly well off. Another key provision for employees, and this is only available for employers that are not taking advantage of the PPP forgiveness program, is that all Social Security taxes on the employer side, 6.2%, can now be delayed until December 31st, 2021 for 50% and December 31st, 2020. The next two provisions are about modifying past returns to sort of monetize losses that might exist on the business's balance sheet. So the first is bonus depreciation is now available for interior improvements to commercial facilities beginning in tax year 2018. And perhaps even more critically, they've changed the business interest deduction rule and increased it, the cap from 30% to 50%. That provision on its own is going to have a huge impact for a lot of businesses in being able to deduct additional interest and limit their tax exposure going forward.
Hey, Ross, you got about 2 minutes.
Perfect. Thanks, Mike. Finally, I'll mention this slide and then one last program. There's been significant modifications to the net operating loss rules, which allow for a 5-year carryback beginning after December 31st, 2017, and have changed the income limitations going back. So a lot of corporations are going to be interested in amending past returns to recoup 2020 losses. And then the final provision is the Payroll Tax Credit. This is available to organizations that maintain payrolls that are under either a shutdown order or whose gross receipts have declined by more than 50% as compared to the same quarter last year. There are two different categories of employers for purposes of implementing this credit. The first is those employers that have less than 100 employees. They can take the credit against all wages paid in a quarter subject to the gross receipts decline or during the shutdown period. But if you have more than 100 employees, it's limited to just those employees that you've sort of idled that are no longer providing services, but otherwise are receiving payroll. And this credit is limited to $5,000 per employee, and it's immediately refundable as an overpayment of employment taxes. Thank you, Mike.
Thanks, Ross. And as Ross mentioned, we're looking at the next relief packages coming down the pike with apparently focus on infrastructure. It sounds like it'll be maybe a tougher political battle, but we'll be all over that and ready to communicate with you around that as well. Now we're going to move to Craig Johnson to talk about supply chain and other logistical issues and strategies for dealing with some of the crunches that are happening. Thanks, Craig. Thanks, Ross.
Good morning, all. I appreciate you attending. As Mike has said, you've gotten some good information about liquidity and some of the CARE Act from previous participants. But basically, I'm going to give you a little bit of the landscape first about the squeeze that's going to come, and it always does come to you as producers, comes not only from the financial institutions taking a hard look at your business, but also from your suppliers and from your customers. And that's where you're going to see. Let's go to the next slide. You've got from the landscape, you've got the biological virus and the contagion from that. You've got the widespread governmental actions that you are all familiar with, stay-at-home, shuttering of businesses, the government determining the winners and losers, essential versus non-essential business. But probably the more long-lasting contagion is from the economic virus and the consequences. Y'all are seeing the liquidity squeezes, I'm sure, already. In fact, we were on the phone all day long with a multinational that was dealing with Latin America and EMEA and liquidity issues all up and down the chain.
You've got the CARE Act and other government bailouts and incentives we've talked about. Next. The effects of this will probably outlast the virus itself, the biological virus, and may well result in some fundamental shifts in the economy. Next. One of the things that I think you should keep in mind, and some of you already are aware of this, but this current contagion has simply aggravated what was already slowing the industrial demand. If you go to the Kitco metals charts for historical, for instance, both for zinc and copper, which are good leading in economic indicators, what's coming down the pike, all of those were downward trending even before the COVID virus. So those are kind of ugly, indicators, although in the recent terms have been going a bit sideways. So that puts both suppliers and customers in a cash squeeze liquidity situation. They then squeeze you as producers to preserve their liquidity. And, there are two effects of that. The suppliers want their cash quicker, or they want to negate contracts that are not favorable to them. The customers want a longer pay cycle. In other words, they want to preserve as much cash as they can get without having to pay you quicker. And as mentioned, we'll mention further a little bit down the road, the financial institutions come in on the side of that. Go ahead. We're going to give you an immediate response for, dealing with this. As Ruth mentioned, it's absolutely important that you form a team, particularly on your supply side and your customer base, of your purchasing, management, finance, sales, and legal. And you should immediately take some analysis of the suppliers and customers. You got to do some due diligence on your long-term contracts, your payable issues, slow pay. You need to look at the cancellation and force majeure possibilities. And note in that, a lot of people will ask, well, can an economic situation be constitute a force majeure? And typically it cannot unless it's written into the contract. That's not a typical act of God force majeure event. You need to look at what's essential, what can be deferred in your CapEx and OpEx, and I'm sure you're already doing that. I heard this morning that one of our primary customers is dealing with what they call the breaking the glass scenario. They're pulling out their emergency survival plans already. You ought to establish a watch list for your suppliers and customers that evidence some financial risk. Particularly, you need to get a handle on this thing as soon as possible. You'll see not only the producers, but you'll also see your suppliers wanting to renegotiate contracts that seem unfavorable. The purchasing discounts in exchange for more rapid payment to your customers, that'll happen on both sides. It's something that you ought to be aware of, and you ought to look at that, whether or not that helps your liquidity or actually in the long run hurts your liquidity. For the precious metals, that's a little bit different situation, but certainly for the base metals, it's a much more serious situation. And whether you look at the contango or the backwardation in both the copper and zinc, those are some serious issues that you need to get a handle on. There's going to be some pressure to accelerate payments of accounts receivable or discounts. You want to try to avoid the mismatch of overcommitting to discounts on the sales side, unless those are balanced by purchasing discounts on the purchasing side. One of the critical things that your in-house counsel ought to be doing immediately is reviewing Article 2 of the Uniform Commercial Code. Every time I've gone through this personally, we've gotten a lot of pressure from suppliers and from customers dealing with anticipatory repudiation of your contracts, demanding adequate assurances of performance on your standpoint, and you can similarly demand that on them. Basically, there is no force majeure under Article 2, but there are, there's unexpected contingencies like this that you need to be aware of and reviewing those. And as Drew said, you got to shore up your bank lines of credit, revolving credit agreements, and look at some alternative financing in the metals business, you know, in the 80s and early 90s, we did a lot of metal borrowings and metal, you know, sale and leaseback, and the gold and silver borrowings and lease payments are at a historic low, and that's, you know, an alternative to sometimes a higher yield of the credit agreement that are demanded by banks, particularly if you do swap agreements. The other caution I would make is during stress times, and we've seen this with one of our clients when I was in-house, suddenly low-cost suppliers often appear, and they're offering, you know, inferior or counterfeit products. We had a tire contract that suddenly the tires, instead of Michelin tires, had Michelin stamped on them, and they were, you know, basically falling apart on our loaders within days. It looked like a good deal at the time, and in fact, it was the only tires available, but when our guys got them, they were very, very unhappy. It's important that you go to, you know, blockchain tracking and verification if you can. Guard Time has got a great product. You can look them up. Some other, you know, blockchain companies who simply got good. You have to start working on your restructuring and bankruptcy plan now. One of the biggest mistakes people make is they wait too long. You got to have cash to come out of a restructuring and bankruptcy successfully, and Chris is going to talk about that. And it can be a very, very valuable tool as leverage to your suppliers and customers. Next. Jason, so I took the CDC's 5 steps recommendation and turned them into 5 steps for you. On the left is the CDC recommendations. On the right is what I've done. Watch your budget frequently. Take a hard look at your OPEX, CAPEX. Practice financial discipline, fiscal discipline. Avoid making rash or involuntary decisions. This stuff will get better. It may take a while, but it will get better. Maintain disciplined relations with suppliers and customers. And the 5th is seek professional assistance early. And that's all.
So thanks, Craig, and thanks for sharing, you know, your experiences having lived through these. Those are extremely valuable things to share with the group. So now we're going to shift to Bruce White, who's going to focus on the workouts and restructuring bankruptcy options that are available, and I'll just turn it right over to Bruce. Thanks, Bruce.
Good morning, everyone. I apologize for the noise outside my building. I've got a person hanging outside the building washing windows, so you may hear some banging once in a while. We're going to move fairly quickly through these slides, but we absolutely recognize that the energy and mining sectors are highly distressed right now. If you're in the oil industry and oil trading at $20 a barrel, and if you're taking any type of demur on it, you know, you're down another $10. You're at $10 oil, and with that differential. So we understand the scenario. You are in a crisis, and you don't know when that crisis is going to end. Is coal at $34 a ton, natural gas at $1.64. Things are not good in the energy sector. And so one thing that you need to know as we move on with regard to workouts is, as an officer or director of a company, you need to understand what your fiduciary duty is. Next slide. That fiduciary duty that officers and directors have, you have a duty of care. And that care, it means act. You got to be proactive. Next slide. Being proactive means just what Craig mentioned. You don't let the company run out of cash. If you run out of cash, you've got a big problem, as you can imagine. You're going to be liquidating instead of trying to reorganize. As an officer and director, you cannot stick your head in the sand. Again, you got to be proactive. As an officer and director, you also need to know that your fiduciary duty when you're approaching the zone of insolvency, your duty shifts to creditors. What is zone of insolvency? Well, that's when your balance sheet is upside down. Your liabilities exceed your assets, or you can't pay your creditors when the debts are due. That's when you're approaching the zone of insolvency. That's when your fiduciary duty expands to include creditors. And the issue of deepening insolvency becomes an issue. Well, how do you meet your fiduciary duty as an officer and director? The big issue is hire professionals. Hire professionals that have done this before and that specialize in workouts, specialize in reorganizations. You get an objective analysis. You rebuild your business plan, and you do it with professionals to help you through that process. Next slide. Those professionals are a good financial advisor. Now, this financial advisor isn't just a typical accountant. This financial advisor is someone that is solid, that has a reorganization background, that can testify if you've got to go to court on valuation, on feasibility of your plan, on the reporting requirements. There are a number of these experts out there, but you got to find the right expert. And hand in hand with that financial advisor is the restructuring attorney. I can't emphasize this enough. You don't pick an attorney that was your brother-in-law's friend. You've got to pick someone that knows how to restructure a business, knows how to help you rebalance your balance sheet, and works closely with that financial advisor, can tell you what your limitations are, how to deal with creditors, and what you can and cannot do legally. And oftentimes in a stress situation, particularly when your business plan does not balance and you have no way out of it, you may be putting the company up for sale or the assets up for sale. An investment banker that has done this before, can quickly put together a teaser and a book to take it to market, to market the assets. And then, of course, you do have other professionals that'll be part of that process. Next slide. If you, with regard to your alternatives, obviously workouts and forbearances is your best bet. But before you go to your lenders, you've got to have a plan. You've got to understand what your business plan is, because your lenders are going to say, well, is this a temporary fix or is this a long-term fix? And quite frankly, when you're in such a crisis as this, it may be just a temporary fix as you work on your business plan to survive this and work out of this. But the best part is an agreement with your lenders, with your vendors, and doing that through forbearance agreements without going to court or any type of formal process. When you either stick your head in the sand and you aren't proactive, lenders will put pressure on you. And the way they put pressure on you is B and C. They institute state court receiver actions or federal court receivership actions, and they force you by, in essence, taking the assets away from you or taking the company away from you and putting a receiver in place over those assets. That's the worst case for you. You don't want that. So you've got to be proactive. The other is a tool that you can use, and it is an assignment for the benefit of creditors. We're not going to touch much on that today. The last, of course, and we always look at bankruptcy as kind of the last resort. Nobody wants to go into bankruptcy, but it's a last resort to help you save the company. In all of these different options, the key component is your business plan. Redeveloping your business plan and balancing your balance sheet. Next slide. These are the players that you're going to see in a workout and then in bankruptcy. You know, you've got your secured creditor. Your secured creditors are critical. You've got to have a good relationship with your secured creditors. And the best way to have the relationship is to talk with them. Don't ignore their calls, talk with them, and make sure that you're giving them the information you have. You've got to show that they can have confidence in you and trust you. If they don't have that trust, doesn't matter what you do. They will take action to get rid of you. You're going to see bondholders or indenture trustees. Again, this can be both secured or unsecured. You're going to see just your general creditors, your vendors, and your contractor suppliers. You're going to see regulators, and regulators nowadays in restructurings and workouts are taking a stronger stance in things. In the mining cases, in the coal mining cases, you're going to see regulators take a much stronger stance, particularly when it comes to reclamation claims, bonding issues. Of course, you've got to deal with your employees, labor unions, taxing authorities. In a bankruptcy, the additional people you're going to see is obviously the bankruptcy judge, a U.S. trustee, which is an arm of the U.S. Attorney's Office that oversees it, and then a creditors committee. Next slide.
Hey, Jason, did you have a question that came into you that you wanted to present? Is it for this topic?
Mike, let's wait till the transition and presenters. It is not for Bruce.
Okay,
Perfect.
Thank you.
We'll move on. Again, you know, at this critical juncture, you're focused on the workout. You're focused on raising money. How do you get money in? You've got to look at various options. The first and foremost, you look at your current secured creditor. And as you develop your business plan, you're going to determine how much money, how much capital do we need to survive through this? And again, in a scenario, if you're in the oil and gas field, you don't know how long this is going to last. And it may be shutting wells in it for a period of time as you work through this process. Excuse me. Purchase and sale of secured debt is a different way to raise money. There are financial groups out there that are in this space that look for opportunities in the distressed market. You also have a tender offer or exchange offer that is available to you. Next slide. If you end up focusing, if your creditors aren't working with you or you need additional time, it may be a formal bankruptcy that you need to file. Chapter 7 is a liquidation of the business. Chapter 11 is your reorganization. Quite frankly, it's extensive, it's lengthy, it's expensive, and you need to go into that bankruptcy prepared, and we'll talk about that. Chapter 13 is for individuals. A new under the that Congress has put into place is what's called a Subchapter 5. It's part of the Chapter 11. It's for small businesses. The Congress has tried to streamline it with regard to having no creditors committee. A plan is put in place, and you work through the process much quicker. Next slide. Subchapter 5 had a cash limit, or a liability limit of $2.7 million. Under the CARES Act, this was increased to 7.5. So in order to be eligible for a Subchapter 5, your total secured and unsecured debt has to be under 7.5 million, not including coronavirus debt. And so that will be available to smaller companies. I can guarantee you that you're going to see someone in bankruptcy. You're going to see a supplier, you're going to see a customer in bankruptcy, and you're going to need advice on those issues. Next slide. The key components to workout or reorganization is understanding your cash flow, understanding your financing, and in conjunction with that, it's understanding the value of your assets and the relationship with your creditor. And the key to it is developing a business plan. I can't emphasize enough that business plan, as you build it with your financial advisor and your restructuring lawyer, that's the plan that you go sell to your creditors. That's the plan that you're presenting to them as to show, look, we have a plan to survive this crisis, and here's the plan. Now, sometimes you're in a situation where it's just not feasible. It's not, the plan doesn't work. You're so far upside down, or you have so much debt that it's just not feasible. You have the ability to sell your assets. In a bankruptcy, we call that a 363 sale. 363 is the bankruptcy code section that allows the sale of assets. And the key component to it is you can sell the assets free and clear of all liens, claims, and interests to a buyer. And oftentimes, buyers want you to file that bankruptcy so they can get that federal court order that allows the sale free and clear of liens, claims, and interests. Next slide. Out of it. Obviously, the best way is a plan of reorganization. I'm sorry?
Oh, I was just having audio difficulty, but you're back on.
All right. Plan of reorganization. That, again, the key component to that is your business plan. You build a formal plan of reorganization. Creditors get to vote on that plan. It may be a plan of liquidation where you're liquidating it in an orderly manner if your business plan just doesn't model out. It could be an asset sale or dismissal of the case or conversion to a Chapter 7 liquidation. The takeaways is be proactive. Seek professionals that can really help you through the process, help you meet your fiduciary duties. The right company can make it through this. Some companies aren't going to make it through if they're going to be liquidated. That's all I've got. Thanks.
Thanks, Bruce. And Jason, did you want to jump in with a question?
Yes, thanks, Mike. Just for those of you that joined the call a little bit late today, or the webinar a little bit late today, the slides will be available to all participants. A question came in for Ross Keogh concerning the PPP. It was stated that I understand that the PPP loan is only available to 501c3 nonprofits, which excludes trade associations. Any chance that that will be expanded in future packages?
I don't have a good thermometer on what immediate tweaks may be made to the CARES Act, but the question is correct that enabling legislation, the CARES Act does only allow for 501c3s in the nonprofit bucket to have access to the PPP loan framework. I would encourage those sorts of trade associations to look at the 2301 employment credit that I talked about at the very end as a potential bridge or alternative solution, because it is in lieu of the CARES Act or of the PPP provision.
Thanks, Ross. And just as a reminder, please submit all questions to Mike Zodi via the chat. Thanks.
Thanks, Jason. Thanks, Ross. And thank you for the question from the audience. Now we're going to do a quick insurance reminder and overview from Kevin Johnson. Kevin?
Thank you, Mike. I want to talk about three things: coverage limits, policy limits, and notifications. Most people, when they think about insurance, they know they have to have it, they put it in place, they hope they never have to understand what the policy limits are all about or what the policy is all about. We're not here to make insurance experts out of anybody. We're just going to give a really broad overview on certain things, on these three topics, recognizing always that you have to understand that insurance is a financial asset. So when companies are in distress, a lot of times what you need to do is realize that that insurance is a financial asset that perhaps you can use. Let's start with coverage limits. There are a couple of things to keep in mind. One is who is covered. Now, a lot of times the policy will include the insured, the parent company, if you will, and its affiliates. But you have to make sure that that list is always updated and clean. The other thing that people tend to forget is in a lot of contracts, large purchase contracts, supply contracts, there will be a request for the counterparty to be an additional insured. What you have to recognize is that those additional insureds can actually erode the coverage, the coverage that you have, because they will be considered an insured. They will have access to that money. Now, the next thing to think about is what is covered. The way that insurance policies are written is that the coverage is really broad. We'll cover all things from now until the end of the term. The key is not the coverage clause. The key is the exclusions. So you need to make sure that you understand how the exclusions in your policy work. For example, there's often, and this may not apply to many, but there's a nuclear exclusion. There's all kinds of exclusions and limitations. So you need to understand what those exclusions are and how they may affect your policy. The second thing is when you enter into an insurance policy, a lot of times what you do is make representations regarding the policies and the nature of the business. It's important to understand what those representations are and what representations have been made, because insurance companies are in the business of collecting premiums and not paying limits. So what they will do is look to things like the representations that you make in order to see if there's an argument that the representations you made in order to get the policy were inaccurate. Let's talk a little bit about policy limits now. One of the things that we need to think about is when you look at the policy limits, a lot of times what happens is you'll have an occurrence limit and an aggregate limit. Those may be the same, they may be different. Let me give you an example, if I may. So you might see a policy that's $5 million per occurrence and $8 million in the aggregate, or a policy that's $5 million per occurrence and $5 million in the aggregate. The important thing to recognize is that there will be a limit on an occurrence basis, and there will be an overall limit on your policy. And it's important to understand what those limits are and how they're determined. The second thing is make sure you understand your deductibles and your SIRs. SIR stands for self-insurance retention, because that will affect when you're able to get the funds. If you have a $5 million policy but a $250,000 deductible, you're going to have to pay the first $250,000, and you need to make sure you understand how those deductibles and self-insured retentions work through your policy. Some policies also might have subcaps in them. So it's important to understand what kind of loss there may be and if there will be a subcap within that policy limit for those kinds of issues. An example might be business interruption insurance. That you might have, for example, a $10 million policy, but there might be a subcap within that $10 million where you can only use 5 of it, making up a number, or 4 or 3 or 2 for business interruption. So it's important to understand what those subcaps may be, also understanding what the excess layers may be that you have. A lot of times what happens is insurance is done in primary layers and then excess layers. it's important to understand that that entire insurance program to know how that happens. One last thing is, at this point in time, it's probably wise to pull out your insurance policies to start looking at what your policy limits and your coverage limits are, so that you know where you are. And it will be important to make sure that you understand who else may have access to that financial asset, the additional insureds you may have for suppliers, for example. The last thing is our notice requirements. There's a question that you have to ask immediately, which is, have you suffered an event that may trigger potential coverage under your policy? If so, then it will be important to make the appropriate notices of the potential coverage to put the insurance company on notice. Typically, that is done through your broker. You will coordinate with your broker, and the broker will notify the insurance company. But that notification and the timing of the notification is critical, because if you don't timely notify, the insurance company has an argument that because of failure of notification, there is no coverage obligation. And that's it.
Thanks, Kevin. Now we're going to jump back to Rue Goodnow, who's going to drill into bonding issues. And so with that, Rue, I'll just drop it right to you.
Thanks, Mike. Just one thing to add to what Kevin just said. There may be some officers or directors on the phone. You may want to think about the O&D coverage that you have. It's been a while since we've had a downturn like this. Customarily, downturns are also followed by stockholder lawsuits. And Kevin mentioned that the insurance is a financial asset. It's an asset of the bankruptcy estate, and generally need to go seek approval from the bankruptcy estate to exercise your rights that exist independently of the company to a defense and payment in those types of cases where you're brought in as an officer or director. So bonds, they are not insurance, contrary to common misunderstanding. Bond is a financial guarantee of performance. In this context, generally, reclamation obligations for mining are subject to the bond requirements of 43 CFR 3809. The principal, the mining company, is responsible to perform obligations, reclamation obligations, and if the principal doesn't perform the bond, also called by other names financial assurance, for example, is then may then be collected or called. It's probably a little early to be talking about this as something that's going to happen immediately at this stage. Bonds are required to secure a plan of operations, for example. That's the most common use, although there are other uses. And everyone hopes that operations will continue unaffected, or at least hopefully little affected by the current environmental problems that we're experiencing in our economy. But they can happen. It's important for us to recognize, those we're thinking about this, that the authorities charged with administering the environmental and permitting regulations don't generally want to take over property, and neither do the bonding companies. So unless there is a extreme financial situation on the part of a company which is simply unable to continue to perform its obligations, then it's unlikely that the bond will be affected. Bonds stay in full force until reclamation obligations are completed for the area disturbed during their time, during their term. So if you'd like to take a look more carefully at what precisely a bond says, and you can't locate a particular bond, look at the form that is posted on the BLM's publicly available website, and go to paragraph 8 of the standard form of bond, which says that the bond remains in place until the reclamation's completed or a substitute bond has been provided. This whole discussion, though, is distinguishable from the credit facility, which may be used to serve as the source for the funds behind the bond, such as a letter of credit, for example, which may collateralize the bond, but may have additional obligations associated with it. There may be terms contained in the financial agreements pertaining to cost or duration of the bond, financial assurances of the principal, et cetera. Typically, the surety's interest, as I mentioned, though, will be in the continued operation, not taking over the project by the BLM or the NDEP. If you get to that point, it's important to provide notice to the BLM and here in Nevada, the Nevada Department of Environmental Protection, that there is financial distress, so that the mechanisms can be activated to assume responsibility for a property. Hopefully that will not be necessary. Properties can be placed on care and maintenance and then sold after that. And that does happen during the later stages in the bankruptcy process. The couple cases I mentioned earlier involved instances where we were brought in to administer and fund operations for the care and maintenance and wash down of the heaps, and worked out arrangements where we cooperated through the bankruptcy process in financing and also sharing in the continued proceeds from those operations. So those kinds of negotiations can take place, but it's probably at this stage a little early to be talking about doing that. But it's never too early to start planning. Back to you, Mike.
Hey, Rue, I have a quick question. Is there any risk or opportunity for bondholders or those holding the financial instruments to try to force more assets into the surety, if you will, as they see things unfolding?
Depends on the terms of the financing. This is why I differentiated the bond itself from the underlying credit facility that may be in place to secure the bond. That facility may include terms that require continuing financial assurances, continuing asset maintenance levels, and that sort of thing. But the leverage does not really exist to remove or cancel the bond, because, as I mentioned, it remains in place. And so the incentive of a financial institution is not to force an active company into a situation where it has to close down the operations because its bonding facility has been discontinued. Does that help?
Yeah, that helps. That answers the question. Thank you, Rue. So now we're going to jump back to Kevin Johnson. Kevin has been at the tip of the spear, I think, one of the several people, but Kevin's definitely been living this issue of the essential and critical infrastructure, how those have been defined federally, and then how those have been rolled out state and local levels, confusion that's happened, and has some tips to share around that. So, Kevin?
Sure. Before I move into that, just one last thing to consider on Rue's discussion of bonds. What happens is Rue discusses there's financial assurances that back the bonds, and sometimes that can be a letter of credit, it can be cash, and it's just sitting on your balance sheet. When people are looking at your balance sheet, they're going to see a pot of cash and they're going to want it. The key is to make sure that people who may not be familiar with the industry understand the importance of that cash and that people can't get their hands on it. Because if you miss that or you allow that cash to be eroded, that has an effect on your bonds, which affects your permits, which affects your operations. And apologies for doing that, Rue. I just wanted to just throw that out. When we look at the COVID-19 responses, we're going to look at three essential things: the federal guidance, the state responses, and then some recommended actions. As Ross noted, President Trump on March 13th, 2020, declared a national emergency as a result of the novel coronavirus pandemic. Since then, the Cybersecurity and Infrastructure Security Agency, an agency I didn't even know existed before March 13th, started issuing guidelines regarding what the CISA considers critical infrastructure workforce. The latest guidance was on March 28th, 2020, and they include 16 critical areas. The one that most people probably on this call will look at is what is known as critical manufacturing. So it's important to understand that there are certain critical manufacturing aspects to this that can remain open during this shutdown, if you will. And the key is to look at what critical manufacturing means and energy, and determine whether one fits into it. Now, with regard to that, each of those 16 categories has subcategories, and these categories have changed over time. For example, the description of the mining industry under critical manufacturing changed between mid-March and the 28th of March. One thing to recognize is that the CISA emphasizes that this is information for guidance, and that states are responsible for doing or issuing orders, and that the federal government the federal government supports those orders. So that's what the CISA has done. In addition, remember we talk about critical infrastructure workforce. So the Centers for Disease Control have published guidelines for protecting health and safety of critical infrastructure workforce, which ties back into the CISA guidance. There are various things that they encourage. There's a list of it. We don't need to go through all of them. A couple of things to keep in mind is the social distancing, particularly for operations that remain open, the 6-foot guidance, and the guidance for large workforces, and a lot of people have done less than 10, for example. So one of the key aspects there is to recognize when you start looking at those social distancing guidelines, they don't apply to health and safety requirements. For example, OSHA or MSHA. If you have tie-off obligations, confined space obligations, things like that, OSHA and MSHA regulations will supersede that federal guidance. Let's talk just a little bit.
Jason, can we move forward?
Now, as with the CISA guidance, this is information only that's to be used and implemented at a state or municipal level. Let's talk just a little bit about state responses.
Jason, can we move forward, please?
Next.
One more.
There
Thank
we
you.
go. So when we look at the state response, there are a couple of things to think about. One is that many states and municipalities have issued executive orders or health orders dealing with the current pandemic. In our area, the ones that we have seen in particular are in Arizona, California, Idaho, Montana, Nevada, and Utah. So the executive and health orders generally follow the structure of the CISA guidance, though they are tailored to fit certain requirements that are state specific. And they typically come in three categories. A lot of times what you'll see is the second and third category may be connected together, but there really are three separate categories. The first is non-essential businesses. Non-essential businesses would be like gyms and fitness centers, entertainment centers, dine-in, restaurants and bars, barbershops. And again, a lot of this deals with state-specific issues. For example, in Nevada, they have adult entertainment centers, for lack of a better term, that are non-essential businesses. That is a Nevada-specific item. There are essential businesses, and the key to understanding non-essential businesses and essential businesses is when we look at those are more customer-focused outreach. So some of those, they don't want to have customers coming in. Others, they still need to be open to service customers, but they need to follow certain guidelines. Essential businesses would be pharmacies, gas stations, grocery stores, hardware stores, critical trades. You'll want to make sure that your plumber and your electrician can come into your house to fix leaks and things like that. That's what we would mean by critical trades. And then there will be critical infrastructure. They generally follow the CISA guidance with some local nuances. For example, most of the Western United States orders, or orders from the Western states, include mining and petroleum as a critical infrastructure item. There are other states, for example, we were looking at Delaware and Massachusetts. Those do not include mining, because there isn't a whole lot of mining going on there. So there can be some local nuances. Another thing to keep in mind is many state orders have procedures for businesses to petition to be included as an essential business or essential infrastructure. So
Hey, Kevin,
when you look at
got about a minute left.
Okay, so when you look at that, what you need to do is determine whether you need to petition. The second thing is the state responses typically follow the CDC guidance. Now, there are certain states that don't or haven't gotten as aggressive or detailed in their orders, so we need to look at local and municipal orders as well. In Utah, for example, Salt Lake City, Salt Lake County, Summit County, Wasatch County have more refined, nuanced orders than the state of Utah. Just a few recommended actions. Review the state municipal orders to make sure that your business fits. If it doesn't, consider petitioning that it will be seen as a critical infrastructure or an essential business. In the absence of a state or municipal order, follow the CISA guidelines and develop a safety and health policy that follows the CDC guidelines. This will help when we start looking at what businesses are doing in order to meet the requirements. Thank you.
Thank you, Kevin. And now we're going to wrap up with Jacob Santini covering enforcement and compliance relief and permitting challenges. Jacob, take it away.
All right, thank you. I know we're running a little short on time, and I want to leave a little time for some questions at the end. But so the enforcement and compliance issue goes hand in hand with the critical infrastructure determination or analysis that Kevin was just walking through. And it's basically, once you get over that hurdle, the question becomes, what do the operations look like while you're continuing to operate under these extraordinary circumstances, and can and how do we comply with our ongoing permit requirements or regulatory requirements? And a quick example of that would be where travel restrictions or social distancing or even reduced operations are going to impact your facility's ability to conduct a stack test. Your Title V permit will have a definitive date that you have to conduct your stack test, but under these circumstances, can you actually do that? And the national associations have been pretty aggressive with identifying this issue and pushing this forward with the federal agencies to get in front of this. And fortunately, last week, the EPA issued a temporary enforcement policy. It was on Thursday. This policy there's a lot of nuances to it. I'm only going to give you a 10,000 view of this. We could probably spend an hour talking about this. Anyhow, but the fundamental issue the fundamental premise on EPA's temporary enforcement policy is enforcement discretion. Now, enforcement discretion is a well-worn term in environmental law, and it's basically if a facility follows the policy that EPA puts together and makes its best efforts to minimize their emissions or their noncompliance, EPA will withhold a decision to issue a notice of violation or seek civil penalties. Just really quickly, what this doesn't apply to, this isn't an affirmative defense. So if EPA decides they are motivated and wants to seek civil penalties, this isn't an actual defense that you would raise in the proceeding and say we should be scot-free. Of course, you're going to raise these circumstances, but it's not an affirmative defense. This also isn't effective against citizen suits. I have at least one client has told me that after EPA's policy came out, an NGO reached out to them and said, yeah, we see this policy, but you're still going to comply, right? So citizens are looking at this. It doesn't apply to criminal penalties as well. EPA was pretty specific about this doesn't apply to either Superfund or RCRA corrective actions or imports. So backing up to general conditions for this policy, number one thing is EPA says you've got to continue to make your best efforts to comply, right? This isn't an opportunity to put your head in the sand and say we're just not going to comply. You have to try to comply. The other general condition that they put out is basically 5 criteria to follow to make the policy available to yourself. And if you look at these criteria, there's a lot of ambiguity here. Act responsibly under the circumstances. Number 3, take actions necessary in response using your best efforts to comply at the earliest opportunity, return to compliance as soon as possible. This is language that your environmental managers or those dealing with compliance should be, while it's ambiguous, should be a little comfortable with, because this is following a lot of the other enforcement discretion regulations that we see, either it's breakdown rules or emergency provisions in your permits, things like that. So, and this really builds on enforcement discretion. It's you've made your best efforts, you've explained it to us being the agency, and does the agency agree or disagree? So that's where you go. So the next question becomes is, okay, we collect and document this information. What do we do with it? Well, that depends on the type of violation or non-compliance that you're dealing with. For compliance monitoring and reporting, you're going to use your existing permits regulatory scheme or statutes. For instance, a Title V permit, you're going to have deviation reporting or obligations. You're going to need to follow that. If there's no applicable requirement, maintain the information informally. I would also say you may want to be communicating that with the agency so they're aware of it. For acute or imminent threats to human health, this is actually one of the more important issues to be aware of. EPA strongly recommended that even though they have delegated the program to a state, they would like to be aware of this. And the reason they've emphasized that is they basically said, this is where EPA is going to put its energy in and resources under these circumstances. Acute risk, imminent threat, so make them aware of that. Excess emissions, you're going to notify as quickly as possible. You're going to have some overlap with your traditional breakdown rules, emergency provisions, where you already have reporting requirements under that. So you might want to consider expediting things just to make sure an agency is aware of things. And I think, stepping back and thinking about this, the one item that we've seen where an agency will get motivated to bring a notice of violation or to seek civil penalties is where they think they're getting kept in the dark, or a source is purposely trying to not tell them about these things. So you want to be communicating with your agencies as much as you can when things go bump, because sources are going to have hiccups because of this.
Hey, Jacob, you've got about a minute left.
All right. So, well, let's skip ahead to the next slide. MSHA also has some less formal guidance. I think most mining facilities know about this, but they're looking at refresher certifications and they're looking to waive that. The one thing to be clear about on this is that's not just a blanket exemption. You actually have to seek a letter approval of that from the regional office or the field office. Next slide, pipeline safety, pipeline hazardous material safety. They have a formal policy as well. There's a lot of detail in it, but they're again using enforcement discretion. Next is states. They're being less formal. I provided the UDEQ's statement. What you'll notice here is they're not using enforcement discretion language. They're talking about an exemption to environmental rules. So it's a little bit less, that's actually a stronger exemption than enforcement discretion, but we're waiting to see how that actually works. The final thing that I'll just touch on are permitting issues. Nevada the governor issued an executive order stating that all public meetings will be held electronically or telephonically. They're figuring out, I think, how to actually have public comment on that. That's going to slow things down a little bit. The agencies are probably be a little slow in processing things that you normally would want them to process, just because they're trying to figure out how to work remotely as well. We've noted, we're hearing from some sources that contractors are asking for letters or certifications that work as essential as they continue. So with that, apologies that was a very quick overview, but anyhow, happy to answer any specific questions or to talk to you offline as well on any of this. So, thank you.
Okay, well, thank you. We are at 10:30 in the interest of time, and I think we'll just go ahead and wrap it up. I don't have any pressing questions yet. I want to thank everyone who took the time out of their busy and stressful days to join us. We encourage you to reach out to us if you have follow-up questions. If there are other issues you'd like to hear about, please let us know. So we'll go ahead and sign off, but I want to wish everyone safe travels for you and your family. And let's stay connected and let us know how we can help. Thank you again.